and welcome to Legally Speaking with me, Tarun Nangia. Among the promoters community in India and the large business community in India, a huge discussion is raging. What happens in the IBC cases to personal guarantors and their assets, which we also call personal insolvency. And there have been some Supreme Court judgments which have addressed various issues that come up. And today we are going to talk about that in our two-part series. In this part one, we will discuss where have we reached as far as the court judgments are concerned, what areas clarity is needed and what areas are completely unaddressed. May I welcome for today's show, Misha. She's partner with Shardul Amarchand Mangaldas. Good to see you again, Misha. And hope to see some very good interventions from you today. May I welcome Bishwajit Dubey, partner with Cyril Amarchand Mangaldas. Bishwajit, good to see you for the first time on Legally Speaking and hoping for some interesting interventions from you today. Simran Brar, partner Karanjawala and Company. Good to see you again and looking forward to some interesting interventions. Advocate Ishna Kumar, good to see you again. And you were there on the earlier episode on this topic and looking forward for some interesting interventions. So let us start from the beginning. I should request Misha to lay the ground in about 2 minutes before we move ahead with the introductory comments. Misha, the floor is yours.
Thanks, Tarun. Right. So I think today we focus on what all we've covered in terms of judicial pronouncements in relation to personal insolvency. So first question which arose of interpretation in regard to personal insolvency was whether one could proceed against only personal guarantors under the Part 2 of the IBC. And what had happened is that the government had notified only those provisions which relate to personal guarantors and not other individuals and partnership firms, and it got tested in a constitutional challenge before the Supreme Court of India in Lalit Kumar judgment. And in May 2021, the Supreme Court has laid this question to rest, at least, that yes, you can proceed against personal guarantors under the IBC, even though other individuals and partnership firms you cannot proceed against. So the reason and the justification given by the government of India was that because the personal insolvency of personal guarantors is intricately involved with that of a corporate debtors, the principal borrowers, and therefore at the first stage of individual bankruptcy they wanted to enact that of personal guarantors, and that can be proceeded with. Another interesting aspect that Lalit Kumar judgment also puts to rest is that even if a principal borrower in the form of a corporate debtor, its responsibility gets discharged by way of a resolution plan under the IBC, you could still proceed against the personal guarantors for the balance debt. So that was, and what the Supreme Court used the word is that resolution plan, approval against the principal borrower does not ipso facto discharge the guarantee of a personal guarantor. So those were two issues which were, well settled by the Supreme Court. What has recently come up before the Supreme Court is a question as to where should the personal guarantors insolvency action should lie. So we have a section 60 subclause 1 which says that insolvency, resolution, liquidation of the corporate debtors and of personal guarantors will lie before the NCLT. And then 60 subclause 2 and 3 say that it where a personal guarantor is being proceeded against and a principal borrower corporate debtors insolvency is pending before a particular NCLT, then the personal guarantor's insolvency should also lie before the same NCLT or can be transferred there. So the question arose before the NCLAT of interpretation of these seemingly, a bit of contradictory provisions within Section 60, and the NCLAT held that you could always go against a personal guarantor before the NCLT, irrespective of pendency of the principal borrower's, corporate debtor's action in NCLT. That has been stayed by the Supreme Court. And the question is not whether you could go against the principal borrower there. The question is where you should be going, because otherwise, in the personal insolvency part 2, the section and the personal guarantor regulation says that against individuals, the relevant jurisdiction is with that of the DRT. So it's an interesting question which needs to be yet decided by the Supreme Court.
Thank you, Misha, for that opening comment. May I go to Bishwajit Dubey from Cyril Amarchand Mangaldas for his opening comment on the show today.
Sure. Thanks, Tarun. And thanks, Misha, for the introduction. So, as Misha rightly put it, there are two things that come out so far. One is that insofar as personal guarantees are concerned, the legislature as well as the courts have taken a view that it is enforceable, irrespective of the fact that the resolution plan has been approved by the NCLT and the part or full debt is discharged by the resolution applicant. That's number one. Having said that, the issue of jurisdiction as to in a given situation, whether because there can be several situations in a case where the section 7 or any application under section 9 is pending before the NCLT. That's one situation. There could be another situation, which is the principal borrower, as to even before the application is filed. So that's the second situation. Third situation where, and which is, I think there is absolute clarity, where the application is admitted by the NCLT. The other situation is where the plan is approved by the NCLT. Then what happens? And appeal is pending. So the lack of clarity to some extent has arisen in a situation where the application is not even admitted or not even filed. So whether one can say that the application is pending and therefore the proceedings against a personal guarantor can be gone before the NCLT, and whether it should be go before DRT. And as Misha rightly pointed out, in the Jajodia matter, NCLT took a clear view that irrespective of whatever the situation is, NCLT will have jurisdiction wherever the registered office of the principal borrower or the corporate debtor is located. On the other hand, now that the Supreme Court has stayed this order, so therefore we are back to the same situation where we need to see where would the jurisdiction lie. Although if I have to answer that question, I would say that NCLT will have jurisdiction in so far as personal guarantors are concerned, irrespective of whether it is pending or not, because section 60 is quite wide in that sense. It just says that if section 61, if the registered office of the corporate debtor is located, that's where the proceedings can be initiated. But having said that, Supreme Court will finally take a view and then we'll have to follow that. But again, as Misha rightly said, that the issue is only with respect to jurisdiction. The fact that personal guarantor, the lenders can proceed against the personal guarantor is not in question. The second issue that has opened a sort of a question mark on the guarantee itself, enforceability of the guarantee itself, in a situation where the debt is assigned by the lenders to the successful resolution applicant. Now, in that situation, DRT Ahmedabad has actually taken a view that in a situation where the debt is assigned to the successful resolution applicant and there is no underlying debt, therefore, in such a case, the lenders will not be able to enforce it because there is no underlying debt to enforce the personal guarantee. So that again, in my view, has to be tested because there are several other aspects to it. So that's something as is an open-ended question still. And finally, I think Supreme Court will take a view on that. But in this case, the difference is that actually takes away the right of the lenders to enforce it. So here, enforceability itself becomes a question. So that's a larger question that needs to be answered.
That's a larger question that needs some clarification. We'll address it later in the show. Simran Brar, partner from Karanjawala and Partners, your opening comment.
Yes, so I would like to just pick up the bits that were spoken about the Lalit Kumar judgment, really, from both Misha as well as Bishwajit. As far as the judgment is concerned, I think the current DRT judgment, of course, as Bishwajit has already pointed out, it did draw a distinction vis-a-vis the Lalit Kumar judgment. The Lalit Kumar judgment also, we must remember, is as stated in the judgment itself, it is about the constitutional validity when the 2019 amendment was challenged, where the personal guarantors were brought into the ambit of the IBC, etc. So that really pertains to that, and the DRT has taken that and said that in the present case, the SBI versus the Ruiya's case, that it does not apply simply because here there is no underlying debt, and the personal guarantee itself should be looked into, which also the Lalit Kumar case talks of. It doesn't give any comments on the intricate facts of that case except the constitutional validity. So one is that, and two, it does say that it is to be seen in the facts of the personal guarantee itself, which the DRT, as I think, has rightly sort of distinguished versus saying that no, this that a guarantee is can be now enforced.
Okay, thanks for that opening comment. I'll go to Advocate Ishna Kumar for her opening comment.
Yes, just so taking the discussion forward, I think Lalit Kumar was a judgment which recognized the approval of a resolution plan as an operation of law, and I think it laid down a test of there being an operation of law vis-a-vis there being a voluntary consent to the agreement between a principal borrower and a creditor being there. I mean, so that voluntary consent vis-a-vis the operation of law is what the test, I think, is. And it's interesting to see that how DRT, while discussing Lalit Kumar and kind of, I wouldn't say distinguishing it, but really applying it into the facts of the case, while actually dealing with an OA in an RDDB Act. It basically said that today, we are looking at an underlying debt not being there. So I today can't really apply Lalit Kumar to say that, oh, by operation of law, if it has been approved, there is still a debt that will continue, will be really in my my understanding, what I call is unjust enrichment, which commercially we all of us use. So I think the test really is, and taking that further, a thought comes to me that will this then mean that there will be a different test for a dissenting financial creditor vis-a-vis an assenting financial creditor in the committee of creditors, because it is really the voluntary consent of an assenting financial creditor that results into that operation of law. However, in case of a dissenting financial creditor, one could say the contract has not novated so as to discharge the personal guarantee. However, in case of an assenting financial creditor, and that fact being there, only then that there will be an operation of law, is something, is a thought that comes to me. Because if you strictly looked at the contract law, it is very well settled, and that's what I think the DRT Ahmedabad judgment also, while referring to the writ judgment of the Gujarat High Court, says that if the underlying contract between the principal borrower and the creditor is modified in any manner, or there is an act that is done in a manner that is something that is not agreed with the guarantor, then the guarantor automatically gets discharged. For example, there is an OTS or a restructuring that happens between the creditor and the principal borrower. Of course, the guarantor gets discharged as a result of that. So the question I ask myself, and of course, I mean, there will be flip sides to it, that what will happen in this case where an assenting financial creditor actually has given a voluntary consent, and that is the reason that operation of law came into. However, so will that mean that under the contract law, and there, I mean, according to me, there being no conflict under 238, because the code recognizes the coextensivity of personal guarantee and financial creditors. So there being no conflict per se, will under the Contract Act, the personal guarantor stand discharged vis-a-vis the assenting financial creditors who have approved the plan? Or will that really be in the teeth of Lalit Kumar?
Thanks for those inputs. We'll take a short break and we'll be right back. Welcome back. Just before the break, you heard Advocate Ishna Kumar voicing her introductory comment. I'll go to Misha from Shardul Amarshad Mangadas, partner with Sam. Misha, in light of the DRT Ahmedabad judgment, what all changes? Banks, of course, will continue to go after personal guarantors. So does it really change anything?
No, it is certainly a very, very important issue, Tarun, and the way the resolution plans are structured at the present will definitely depend upon the ultimate outcome on this issue. Of course, we have a judgment of the DRT in one way. We have to see how it get tested all the way to the Supreme Court. But some of the issues which are raised by this, all the panelists earlier, they're all very interesting. So I hear where the logic of DRT judgment comes that when there is an assignment of the debt, there is no underlying debt remaining, and what is it that we are enforcing against the personal guarantor. But one needs to see that the resolution plans are typically structured in different ways. So either there is an assignment of debt, or there is at times in the hands of the principal borrower, which is the corporate debtor, there is a complete some part payment, and the rest of it is converted into equity or preference shares. These are all structuring matters. What is also important is that these very plans carve out the personal guarantees and keep them available for enforcement to by the creditor. So even that term needs to be construed, and it needs to have a meaning. Otherwise, there is no meaning for a term like that. So I think this needs to be tested to see what happens. And it's also, at least in Lalit Kumar, the way resolution plan has been seen, it has been seen as by way of operation of law, as Ishna was clarifying, but putting it giving it a flavor that it is only an operation of law, whether assenting or dissenting, it will get, in my mind, little difficult distinction to be made, because the process gets started, and the process may not be started by all the assenting creditors or the dissenting creditors. Maybe it is started by an operational creditor, but it ends up in a resolution plan which is statutorily binding under section 31, including on the guarantors. So that is where I think 31 is the section which gives it the flavor of it being binding by virtue of a operation of law, comparable to a liquidation order. The Lalit Kumar judgment refers to precedents under the earlier regime of winding up and liquidation order, and says that that's a discharge which is not voluntary. It's a result of operation of law. So it's the scheme of IBC which discharges the corporate debtor read with the SR judgment ratio of clean slate, right? So a resolution applicant comes and gives a plan, and as against say 100 rupees debt, 80 is paid by the resolution applicant, but qua the principal borrower, the corporate debtor, there is a clean slate, because the whole idea is that the corporate entity needs to revive and continue as a going concern, and you cannot just keep bringing the old claims, because once and for all you've resolved all those claims and given an answer by way of a resolution plan which is binding on guarantor as well. So in that resolution plan, while it may provide for assignment, it may provide for conversion of debt into equity or whatever balance in the hands of the principal borrower or corporate debtor, does that by itself discharge the personal guarantor, especially when the resolution plan which is binding on that personal guarantor says that the right of the creditor to go after that personal guarantee will remain. And what's also important is are the terms of the guarantee itself. So sometimes these guarantees themselves say that even if there is a voluntary discharge by the creditor of the principal borrower, then that by itself will not discharge me. You come to me as not as only a guarantor, but on a principal to principal basis. So these are some of the more nuances which needs to be tested and seen. Having said that, there's another issue which is very interesting of interplay of resolution plans and personal guarantors, is that of subrogation. Although the SR judgment, the Supreme Court has said that a resolution plan taking away, in the case of SR, your right of subrogation, which is simply put a right of the personal guarantor or a guarantor to step into the shoes of the creditor having paid on behalf of the principal borrower, and take back the money or pursue the claim as if it was the original creditor. That right is taken away by way of a resolution plan, naturally so, because the resolution applicant in his new avatar and in the corporate data doesn't want to be coming and facing the same claim again. And that's a unique principle of IBC because of clean slate, and because of that it says that the right of subrogation can be taken away. So in those guarantees where the guarantor has not given up a right of subrogation in under the terms of the guarantee itself. It's a very important right of a guarantor which goes away, and that in my mind is the unique feature of IBC, that because it is binding on you as under section 31, and it has a universal application rather than just a bipartite between lender and debtor kind of effect. That's an effect which happens on the guarantor, and unfortunately even the guarantor ends up paying, will have no recourse to the principal borrower.
Point well taken. I'll go to Vishwajit Dubey on this point and seek his views.
Thanks, Misha. So I almost fully agree with Misha on this. A couple of small points on this without talking about any particular matter is the issue on the debt. At some level, the debt that is being sought to be enforced or recovered, or that basis the default of which the IBC proceedings have been initiated, is the same with respect to the corporate debtor and the personal guarantor. It is quite clear, and section 14 has also made it clear, that proceedings against the corporate debtor will not bar any proceedings against the personal guarantors, and it's been upheld by Lalit Kumar Jain also. Now, in that light, therefore, the fact of if one debt will have an implication on the other, that needs to be tested when this issue is examined by the higher courts. That's one. Similarly, if you look at the converse of it, if any proceedings under the IBC are any application is filed against the personal guarantor, it automatically interim moratorium starts. Now, in that situation, there is an argument which says that therefore the proceedings against the corporate debtor cannot be initiated or cannot be continued because of the interim moratorium that hits in. So therefore, when we talk about the underlying debt, if it IBC itself is somewhere, the code itself, the way it is structured, and as also clarified by the court, is that the debt to that extent is somewhere segregated, that if you can proceed against one, it does not stop the proceedings against the other automatically. So therefore, in my view, this issue needs to be examined, whether if just because there is an assignment, it will have a bearing in the sense that the banks will lose out their rights, because the judgments have also been clear about the fact that the guarantee is enforceable, right? So the issue of enforceability has so far not been discouraged in any of the higher forums. So I think that needs to be looked into.
Okay, point well taken. I'll go to Simran Brar from Karanjawala and Company at this point. Simran, in light of the DRT Ahmedabad judgment, and the Supreme Court judgment was binding in this case of Lalit Kumar Jain versus Union of India, how would you look at the DRT Ahmedabad judgment?
So Tarun, I would say that the DRT judgment to that extent has not just for the Lalit Kumar judgment, but has also kept in account the sanctity given to the resolution plan, which is finally approved by the NCLT in all cases. So we have to remember that a resolution plan is approved by the COC and eventually gets the stamp of approval. We also have to remember that the NCLT's scope to interfere once all this is done is very limited. And when a debt is there, payments have been made. Once payments have been made and once payments have been accepted by the financial creditors, there is some closure to the whole process, which I think in a way goes to say that the debt has been paid off in its entirety, which the DRT judgment acknowledges or observes or holds. And therefore, for a financial creditor to once again to come and try to encash his ticket twice, in a way of speaking, is what I think the DRT judgment has said that can't be done, because the debt is clear now for you. I mean, at the end of the day, the personal guarantee really was given as a surety for the initial debt, for XYZ reasons. Now, when you have accepted whatever proportion or percentage of, the payment that, you have as a creditor, and you come once again to say that now I need to enforce the personal guarantee, the DRT has frankly given its opinion how it has. And interestingly, an appeal has just been lodged by the SBI. And I'm sure, as we all know, it'll go all the way to the Supreme Court. So let's see about that. Yeah.
Good. Advocate Ishna Kumar, you heard Misha, Bishwajit, Simran, and strictly, sticking to the DRT Ahmedabad judgment, where do you see this going? Because I think a lot of people are going to be watching how this ends.
Right. So I think I take one cue forward from this. This judgment really was a case where they were dealing with an assignment in a resolution plan. I take it, to a different engine to say where there is a case of an assignment per se of a debt. Say, we all know banks have assigned debts to, say, Edelweiss or, JM Finance. These assignments we've seen. So I think one proposition the judgment clearly lays down, and I think nobody will be able to toy with it so much so that it will be in line with Lalit Kumar as well, is that where there is an assignment per se under a contract, that assignment will 100% discharge the personal guarantor because of the Contract Act. So what I'm trying to say is that in case there is a bank which has assigned its debt to Edelweiss, in that case, the personal guarantee cannot be invoked at all. Because that agreement, unless and until, of course, that personal guarantee has been entered into specifically with the assignee, that is the restructuring company. Secondly, the point I think that Bishwajit was making, and with regard to there being what I may see as simultaneous CIRP processes of the corporate entity in the form of a financial creditor vis-a-vis the guarantor, be it a corporate guarantor or like we're talking a personal guarantor, there will come in that factor of the part of the debt not being crystallized in one CIRP and there being a claim without prejudice to the claim that has been filed in the corporate insolvency vis-a-vis the personal insolvency. So I think that might head to some sort of consolidation of corporate insolvency with the personal guarantee insolvency. And there I think the question which we started with, that is with regard to the jurisdiction, becomes very important. Because in that case, the consolidation and the transfer to NCLT will become very important. And in that regard, I think DRT's jurisdiction will get very limited. Third point, and I close on that, is that we will have to be also very conscious of the fact that, personal insolvency does not become a recovery proceeding. And as we all know, that the ambit of insolvency is, of course, not recovery, and it is resolution really eventually. So all the law of, there being a demand being made when a default comes in and then only that personal insolvency is invoked, that would also be an important step forward in personal insolvency. Thanks, Tarun.
Thanks for all these inputs. We are out of time on part one. What was a very interesting episode, if I may say. A lot of promoters are very keen to see where this goes. And that is why we'll get opportunity to do many more episodes on this. But I think this episode comes to an end. I should thank Misha, partner Shardul Amarchand Mangaldas, Bishwajit Dubey, who joined us for the first time. His partner Cyril Amarchand Mangaldas, Simran Rad, partner Karanjawala and Company, and Advocate Ishna Kumar. Thank you for all your inputs. Thank you, viewers, for joining in. Thank you very much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.